So, good afternoon and welcome to the latest instalment of Kent Law School's Summer of Law webinar series. My name is Hannah Phillips and I'm a lecturer here at KLS. You will most likely encounter me in my capacity as convener of the English Legal Systems and Skills module in your first year, and you may also have me as your seminar leader for Foundations of Property in the spring. In addition to this, I also teach second year modules, I convene land law, and I teach seminars in the law of equity and trusts. I'm here today with my colleague Marie, who's now going to introduce herself.
Good afternoon, everybody. It's nice to see so many of you virtually here. As Hannah said, my name is Marie Kerin, and I'm also a lecturer here at the University of Kent's Kent Law School. So I teach on some of the first year modules as well. I teach on Foundations of Property, and I also teach on a critical introduction to law. My main area of interest is the philosophy of law and things around that area. So I often teach on the philosophy of law module, and I've also convened the morality in law module. So I'm particularly interested today in thinking about what do courts do around the decision-making things that we might be looking at in today's session around morality and these kind of things. So I'm really looking forward to those discussions.
Right, I'm now going to share some slides with you guys that both Marie and I are going to talk to. So on your screen, you will hopefully now be able to see some slides. So I'll talk you through to this one.
Fantastic. So hopefully some of you have already been to a few of our Summer of Law webinars. We're upping the ante a little bit this time round, and we're going to try something a little bit different. So we're hoping to use Ombia, which is a polling platform. And so what we would like you to do for us is, if you could log on to that website there, you can either use the QR code and just scan it on your mobile device, or go to ra.ombia.com. All you need to do is pop in your name and then you enter the session ID, and that is KLS 2020, so 2020, so KLS 2020, and then you will come onto our polling platform. So we are going to make use of this throughout some of today's discussion. We're going to be asking you some questions. Some of them will be kind of votes, others there will be a free text option, and we're hoping that will just give you a little bit more engagement in today's session. It might be that you might want to use a different device in order to access this. So bear that in mind, but please as well, do not worry if you're not able to access this software. It's absolutely not going to be a problem in terms of your engagement in today's session. So what we're also going to do, as we've done in the past sessions, is we are going to make use of the raise hand function for some of our votes. And we're also, in addition to the Ombia, we're going to be asking you to give us some comments in the chat. So just to say, with the comments in the chat, you can feel free to be absolutely honest, because those comments are shared with nobody but myself and Hannah, our team here. So we will be then sharing your views around our discussions today, but we're going to make sure that everything is kept anonymous. So do feel free to be honest in using that chat function, and don't worry if you can't get onto the Ombia, but if you can get onto it, please just go there now. So that is just ra.ombia.com, and then you just need to enter our session ID KLS 2020, and you'll be in the same room as us. And we'll give you another reminder when the session proceeds, when we actually start using the polling function to try and get a bit of interactivity in today's discussion. Thank you, Hannah.
Perfect. Right, so today we are going to be taking a look at what our courts do, paying particular attention to the sort of wider issues that arise as cases progress through our legal system. To start with, I'm going to give you a very quick overview of the various courts and tribunals that you are likely to encounter during your studies, and then we're going to take a look at a couple of examples. The first one will be a fictional situation involving a road traffic accident, and the second will relate to the tragic case of Charlie Gard. So, for those of you that have already been attending a few of these sessions, you will hopefully know that Parliament acts as our most authoritative source of law, enacting pieces of legislation that must then be applied in our courts. But as I said, today we're going to be focusing on what is exactly going on in our courts, looking at how everyday problems can be transformed into legal ones that we can then at least try to resolve through our legal system. However, before we take a look at what our legal system looks like, a few important distinctions need to be made. So to start with, we have traditionally been regarded as having an adversarial legal system, where priority is given to the rights of parties to collect evidence, to present it in a way that suits them at trial, and then to challenge opposing witnesses through oral cross-examination. In England and Wales, we use our common law adversarial system to determine facts in the adjudication of disputes. So, for example, in a criminal case, we will have the prosecution and then we'll have the defence, and they will effectively compete against each other with a judge acting as a referee almost to ensure that legal rules and procedure are being adhered to. And this is what you're all probably familiar with from watching TV and films. It's interesting to note that when you start your legal education, you're going to be encouraged to be thinking about law in terms of categories. Now, this is because categories provide us with a useful way of assigning particular types of cases to particular routes through our legal system. So, for example, it is possible to divide cases under the overarching categories of public law and private law, where public law is that area of law that deals with the Constitution. In other words, the relationship between individuals and the state, and relationships between individuals that are of direct concern to the state. And this would include cases like the Miller case that Mo and Sebastian introduced you to last week. In contrast, private law can be regarded as that area of law that focuses on relationships between individuals that are not of direct concern to the state. So this is going to include cases like contract law and land law. We also have the organisational categories of criminal and civil, with the former obviously dealing with criminal matters and the latter dealing with everything else besides. Now, while some situations can be viewed from both criminal and civil perspectives, we really need to be careful not to muddle the two. This is because different rules and procedures apply in different types of cases. So let's take a closer look at what I mean by this. So hopefully on the slide, you can now see a simplified overview of our court and tribunal system. Now I've color-coded things to try and make it a bit more manageable. So I have colored our trial courts in yellow, and our trial courts are also known as courts of first instance. And I put our appellate courts in blue. Now the green courts act as both courts of first instance and appellate courts. So they have this dual jurisdiction, if you like. More generally speaking, you may also hear people refer to senior and inferior courts. So our senior courts would be those blue ones towards the top, and our inferior courts is everything beneath that. Now, you're probably wondering what on earth is a court of first instance. So a court of first instance is basically a trial court. It's the court in which proceedings commence, where they're initiated. And then an appeal court is a bit more obvious from its name. It's a court that hears appeal. Now, appellate courts, they don't receive evidence from witnesses. Instead, they read documents and they hear arguments from counsel. So the delivery is slightly different in these different types of courts. Now, sadly, we don't have time today to go into too much detail when it comes to exactly what each court does, but I can give you a very quick snapshot of the types of work undertaken by each of the courts on this slide. For those of you that want more information, I've put a link down there at the bottom. But let's start off by taking a look at our courts with criminal jurisdiction. So if we work from the bottom up, so you will see that it's our magistrates' courts and the Crown courts that function as the courts of first instance in criminal proceedings. And while the magistrates' courts deal with things like issuing warrants for search or arrest and trying summary offences, the Crown Court acts as a court of first instance for indictable offences, so the more serious ones like rape and murder. In its capacity as an appellate court, it also hears appeals from the magistrates' courts, along with committals for sentencing from the magistrates' courts, where the magistrates' maximum sentencing powers are inadequate. If we then move up the slide, you will see we have the High Court, which is divided into these 3 divisions. It's actually the Queen's Bench division that is relevant in criminal proceedings, and it's there where you can actually hear appeals from the magistrates' courts. Now, finally, we then have the Court of Appeal and the Supreme Court, and you will notice that the Court of Appeal has a special division for criminal cases and another for civil. If we turn our attention to courts that have civil jurisdiction, again, we start from the bottom up, you will see that it is the County Court and the High Court that act as the courts of first instance in civil proceedings. Although it is worth noting that the Magistrates' Court has limited jurisdiction to deal with a few matters, but we'll bracket that off and you can worry about that next year or in September. Now, most civil cases kind of start their life in the County Court. It's only really the most complex cases that start life in the High Court. So County Court as the court of first instance. Now, as we say, if we move up to look at the High Court, you can see there are 3 distinct divisions. Now, in addition to hearing appeals from the magistrates' courts, the Queen's Bench division also hears contract and tort actions, contempt of court situations, and it's also home to a number of specialised courts like the commercial courts or the administrative court, which deals with judicial review like Mo and Sebastian were talking about. You then have the family division that hears family law cases, and the chancery division that deals with a vast range of cases involving things like wills, trusts, land and mortgage actions, and bankruptcy. And then just as with criminal proceedings, we have Court of Appeal and the Supreme Court. Now, the observant amongst you will notice that I've kind of left out tribunals. I've done that to avoid overcomplicating things at this stage. Like, I could show you a diagram, but it would terrify you, so I'm not going to. But the super keen, again, I've put another link right there at the bottom where you can get a nice kind of simplified overview of what they are. They're just basically a parallel system of tribunals that resolve disputes in less formal ways. Now, there are some additional factors you're going to need to think about, so I'm going to hand you over to Marie, who's now going to talk you through some additional things to keep in mind when we're looking at our legal system.
Perfect, thank you, Hannah. So Hannah has just taken us through the court structure in the United Kingdom, but as you can see from the slides that we've just popped up, there's one thing in particular that was missing, and that was the idea around EU law and how that fits into the UK system of law. Now, today is not a day to be talking about Brexit, and so I won't be doing that, but as you know, Brexit will obviously be having some kind of impact on the way that our law might work. But it's really important to know that EU law and human rights law in particular do still influence the laws and will continue to influence the laws in the United Kingdom, even when Britain does leave the European Union. So some EU laws, such as treaties and regulations, apply in the UK without any kind of further domestic implementation. So what that means is that the EU can enact something, a treaty or a regulation, and it simply becomes law in the United Kingdom. There are other types of EU law as well, such as directives, and they need the UK to take further steps by enacting them through domestic legislation. So that would mean that we in the United Kingdom would need to take further steps in order for that to become UK law, even though it has been kind of directed, as it were, via those directives via EU law. As I say, you don't need to know about the ins and outs of these kinds of things or about the impact of Brexit. This is something that you, if you were going to be joining us in September, would be picking up in Public Law 1 in your first year and thinking about the role of EU law. But it is just worth noting that when you're engaging with statutes and with case law in UK law, there is going to be some kind of EU law influence along the way with certain laws that we have. So that was the first area, EU law. The second area, which is a bit more relevant to today's discussion, is the role of human rights law. So the European Convention on Human Rights was effectively enacted in UK law via the Human Rights Act of 1998. which didn't actually come into effect until the year 2000. This legislation enshrines certain rights in our laws, and it means that not only can UK citizens challenge breaches of human rights at a UK level, they can also take their cases right through to the European Court on Human Rights. So we can see then that this legislation is actually quite powerful, because what it means is that courts are now required to interpret all UK law so far as possible in a way that is compatible with the Human Rights Act, and that our citizens then have recourse to challenging other decisions, certain decisions, should it be found that actually there's a potential breach maybe of human rights law. So the reason why I'm kind of dwelled on that one a little bit more is because we will see in the scenario 2 that we will be looking at today, in the case of Charlie Gard, that in fact that case did have some human rights implications. And so whilst on Hannah's diagram, we saw the UK Supreme Court as the highest court in the United Kingdom. We also see in the case of Charlie Gard that actually that got challenged as well, even in the European Court of Human Rights, taking it that step further beyond UK jurisdictions. And I think that's probably the final piece in our puzzle in terms of our court structures for today.
Perfect. So a key question that many of you may now have is, how on earth does a case progress through this system of courts whilst keeping these additional factors in mind? The answer to this question lies in the guiding principles that our judges draw upon as they're deciding cases. So our courts function according to this principle of loyalty, which involves all of our inferior courts following the decisions of our superior courts. So generally speaking, all non-appellate courts are required to apply and follow precedent set in the appellate courts, with precedent being the word that we give to past decisions that are used as authority for reaching the same decision in subsequent cases. Now that's a bit complicated, so to put that another way, when deciding a case, a judge must establish what the facts are and then apply the law to them. After applying the law and reaching a decision, the judge then produces a judgment. And by deciding how the law ought to be applied to a particular factual scenario, precedent is formed, this way of resolving similar disputes. So in the judgments that are issued by our courts, we have lots of different information being included. And we also have the main judgments, which are comprised of various elements. So on the slide there, I've put some horrible Latin. Again, you don't need to worry about that just yet. But we have the idea that some parts of a judgment are binding, and we refer to these as the ratio. And other elements of the judgment are merely persuasive, and they're referred to as obiter. So when an inferior court is trying to decide a case, they will look for past precedent, a case involving similar factual scenarios, and they will look at how the superior court resolved it. And they will be bound by the ratio, the binding part of the judgment, when it comes to how they decide to resolve the dispute. Now, if all of this sounds a little bit complicated, I'm afraid that's because it is. So the next question you may be asking, like, why on earth do people choose to make use of our legal system to resolve their disputes? Surely there's a better way. And there probably is, to be honest with you, in most cases. But this is an especially interesting thing to reflect upon when we're thinking about what it is that people can expect to get out of pursuing legal action. So if you win your case, you will be entitled to a remedy, but the remedy you receive may not necessarily be the one that you want. In a criminal case, the outcome could lead to someone being awarded a custodial sentence. In civil cases, the outcome usually involves monetary payment. But is this really enough to solve the dispute? So let's take a look at a couple of examples to test this. So the first example we have involves a young man called Tom. So Tom has recently passed his driving test, and to celebrate, he has arranged to meet his friends for dinner in town. During dinner, he drinks several glasses of wine, but decides that he feels well enough to drive himself home. On his way home, he approaches a busy junction, and he is about to look to his left, but is distracted by a couple arguing in the car to his right. Without further thought, he turns left, ploughing into Priya. Now, Priya is knocked from her bike, And while she had been wearing a high visibility jacket, she had not been wearing a helmet. After being taken to hospital, it transpires that Priya has sustained life-changing head injuries, and she will most likely require round-the-clock care for the rest of her life. So what do we think about this? Oh, you're muted, Marie.
I'm always going to do that at least once, aren't I? I'm now unmuted. Fantastic. So this is the first poll that we want to be using. So I can see that a few more people arrived just before, just after, sorry, we gave our introduction. So this is just to let everybody know we are using Ombia. So I've put in the chat ID here, the chat discussion, sorry. If you go to ra.ombia.com, our session ID is KLS 2020, and you can get involved in our poll so that we can use Ombia. If you can't do that, then absolutely just pop your answers into the chat, and we will be able to see them as a team and kind of report back. But just a reminder that everything that we report back will be anonymous, so nobody's names are going to be used. So, on with the show, what sort of liability could arise here? Do we have A, civil, B, criminal, and C, civil and criminal, or D, none of the above? Somebody's just asked me if I could repeat the question because they lost connection. So we're thinking about the scenario around Tom and Priya and what kinds of liabilities could arise in that scenario. So is it A, civil, B, criminal, C, civil and criminal, or D, none of the above?
Now I've done it. We've got a few kind of answers coming through in the chat. So I'll give you 5 seconds and I'm going to press a button which will reveal your answers. So if you want to vote, vote now. No? Okay. So chart is being compiled. It's all very exciting.
Drum roll, please.
Okay, that's quite an interesting split, isn't it?
That's an interesting split, and if we look in the chat as well, it does seem that most people are saying civil and criminal. We have a few for civil, a few more for criminal, but then mainly we do have civil and criminal in the responses.
Okay, so I'll give you an answer here. So I think the answer here is civil and criminal. So we've got a mixture. So the majority of you picked up on the fact that we've got both types of liability here.
Perfect. So we're off to an excellent start, team. So one of the things, so what we'll do now is we will take them step by step. So let's start with our civil proceedings. So let's get the procedural thing out of the way first. In which court would civil proceedings commence? So here on Ombia, you should have a free text box where you can just type in which court you think it's going to commence in, or you can just pop that in the chat for us and we'll collate it for you. So first things first, in which court would civil proceedings actually commence? I'm loving this. We're having some people in the chat who are not only confirming which court they think it's going to be in, but whether or not it's a court of first instance or not, which is fantastic.
Great. So again, 5 seconds to kind of participate in this poll, either using Ombia or the chat. Okay, so we've got lots of things. So we've got, I'll explain, like, Marie, do you want to explain what the bigger sizes mean on that result?
Yeah. So the way that this works is that if the words are really big, it means that more of you were saying those kind of things. So more people have been saying county court there. We've got a few others who are saying high court. We've got some magistrates court in there. We've got clarification whether or not it's an inferior one. And in the chat, we're seeing a similar kind of pattern. So we've got a mixture here really between magistrates court and county court. And quite a few people clarifying that they think that that would be a court of first instance or an inferior court. How does that sound, Hannah?
Well, there's lots of interesting responses. I love the fact you've kind of cottoned onto the inferior court, but yes, we're dealing with an inferior court here. And I understand the urge to jump to magistrates, and we'll talk about those when it comes to criminal proceedings. But when it comes to civil proceedings here, we'll remember it will be kind of most likely the county court or the high court where proceedings will start. Now, which court will be determined by the seriousness of the case. So again, as the very exciting procedure element goes, in a civil claim, they can be expensive, they can take a long time. So to try and speed things up, we have, based on the cost, perfect in the chat. So we have the idea where we allocate proceedings according to the complexity of the case. So we're going to need to know kind of, well, how much in damages is Priya hoping to get? How complicated are her injuries? Does she need to use lots of expert evidence? How serious is this case? Like, drink driving is a big issue, isn't it? So you want a deterrent factor as well. So cases are allocated to one of three tracks. We have the small claims track, which kind of gives it in the name. We have something called the fast track, and then we have the multi-track. Now, in this kind of situation, it's probably going to be the fast track that would be used here, in which case we're looking most likely at starting out in the county courts. Now, what kind of made you think that things were going to be going this way? Like, why do we have civil liability in this situation?
So if you want to use the chat for your answers here, team, what we want to be thinking about are what elements, what about the scenario that Hannah gave us made you think that actually this might be a civil thing going on here? Was there something in particular that happened? Waiting for some responses here. So absolutely, one of the things that somebody is picking up on here is that, you know, it might be about the cost of the damage or to get compensation, to gain justice, duty of care. Absolutely, those are the kind of considerations that we want to be having in order to even bring a claim, right? So someone might have something happen to them and then decide that they don't want to actually bring a claim because they don't want damages or it's not going to be worth it and all those kind of things. But I'm wondering more specifically for this scenario, what about it might allow them to even get damages? So somebody in the chat has just said the lack of the cyclist wearing a helmet or not abiding by the road laws. Again, somebody else, a few people actually are picking up on this idea of the helmet. Somebody said personal injury, not property. That's an interesting one there, Hannah.
Absolutely. So we've got, loads of really interesting comments here. So we're definitely looking at a personal injury type of situation, aren't we? So she's possibly not that interested, well, she may be interested in damage to her bike, but it's about harm caused to an individual, isn't it? Now, again, lots of interesting things about the helmet. So let's try and unpick this. So some of you were saying about this idea of a duty of care and to gain justice. Now, I'm not a tort lawyer, so I will hold my hands up right now. But this would most likely, in terms of civil wrongs, it would be the tort of negligence. So you have the idea that as a road user, you have a duty to take reasonable care to avoid causing damage to others that are either using or present on the highway. So you owe this duty of care. Now, the standard of that duty of care, what do we think that is? Like, are there any factors in that scenario that maybe we should take into consideration when we're determining the standard we should hold Tom to? I'm being annoying asking you questions now. Who owed duty? So the idea that maybe Tom owed Priya a duty. So if we're trying to decide kind of the level of our expectations, what we could expect from him, is there anything in the facts? Standards of a qualified driver. Okay, so he's newly qualified, isn't he? I'm going to shatter your bubbles. I'm afraid like the fact that is an interesting factor, but the law will not actually look at the fact that he's only just qualified as a driver. The case I remember from my undergrad was Nettleship and Weston. That's seared into my brain. But the idea is the standard we expect of a driver is that of the ordinary driver. Yes, he wasn't looking left, was he? So the idea that he was maybe being a bit careless. So we have the idea he owes this general duty as a driver on the road, and he maybe fell below that duty. He breached that duty by not looking left and being distracted. So there's been a breach. We then have the idea for negligence. We look for the idea that that breach caused the damage, so the causation, remoteness, foreseeability arguments, and we have that clear connection between that distraction and him ploughing into Priya. But then we have the idea that maybe we can lessen his culpability. So he's looking pretty stuffed right now, kind of thing. Negligence is a likely thing, but are there any factors that would lessen his liability here? So he wasn't looking left, he was distracted.
Oh, an excellent point in the chat here. We definitely have a lawyer amongst us. They've said, would you have to do a full evaluation of the car? So perhaps the car brakes were broken.
Okay, interesting. So yeah, we're going to need to look at the full kind of, is he entirely responsible? Is he entirely to blame? His delayed reactions, maybe?
Yep, absolutely. And we've also got a few people pointing out this idea around the helmet. So the fact that Priya wasn't wearing a helmet, so maybe she was actually the irresponsible one. Somebody's also commented that the cyclist was on the wrong side of the road. I can't recall from the...
So that is my awful use of images.
Okay.
It's my incompetence, not Priya's. But no, if Priya was on the wrong side of the road, that is going to matter. The fight he heard, the couple are arguing. Now, again, I think that's really interesting. Now, I would say the thing the courts would be interested here is the helmet, as you're rightly saying. So in the law of negligence, we have this thing called contributory negligence, which could be raised as a defense by Tom, where basically he says that Priya is partially responsible for the injury that she has sustained. Now, does that sound fair to you? Do you think contributory negligence as an idea, should we be able to lessen Tom's culpability because of Priya's actions?
We have an immediate yes in the chat.
I love that, nice and assertive. Yes, yep. It should. Fair enough. You may be a bit disappointed to hear that, yes, it would be relevant, but the evidence on the efficacy of wearing a helmet is inconclusive. So the courts actually want to look for further evidence to say, well, would wearing a helmet actually have protected Priya? If they cannot be 100% or very, very sure that her injuries would have been less serious, then they cannot use contributory negligence to completely negate Tom's culpability, his liability, but it could be used to reduce damages.
And it's fantastic that people are picking up on that in the chat, Hannah, too. So somebody did say, just before you said that it really does depend on how much of the damage could have been prevented by the helmet. So we've got another budding law student there for sure. And we've also got this idea that maybe we would need to draw on things like medical reports and using evidence and that kind of thing to support exactly what you're saying.
I'm also liking the comments you've got about the drinking and maybe the criminal element of it, which is good because, again, in the civil, like I said, cases can be both criminal and civil. So here Priya could be pursuing both a civil action, but Tom could also be prosecuted. So if Tom is convicted of some criminal offence, Priya could actually make use of that as evidence of his negligence. So criminal convictions in relation to the same situation won't necessarily be definitive, but it can push things more in Priya's favour. So yeah, a lot of you are making really good connections here.
I'm just mindful of the time there, Hannah, because
sorry.
Just because we want to get onto scenario 2 at some point. So maybe in thinking about that criminal element, it would be a good point for us to quickly go over that area before we move on from this scenario. First things first, again, team, we need to think about the procedural matters. I personally refrain from calling them boring because I am not procedurally inclined, but they are very, very important parts. So let's get a little vote up on our Ombia here. In which court would criminal proceedings commence? Which one do we think? We'll just give you a couple of seconds here.
Okay, 5 seconds, and then I'll click to reveal your...
So again, the big here is how many people have voted on it. I would say from the chat, We're a bit more evenly split in the chat. So I think we've got a mix in the chat, Hannah, of 50-50 in terms of Crown Court and Magistrates Court.
Okay, interesting. So I suppose my gut instinct would be to say that this is really going to start in the magistrates' courts. Like the magistrates act as the court of first instance for the bulk of criminal proceedings, not start out in the Crown Court. But we also have the idea of the type of offence that has been committed here. So like I suggested, I use these words of summary and indictable offences. So indictable offences are the really serious ones like rape and murder, as I suggested. And they go, that's the Crown Court's territory. Less serious kind of your everyday offences, including kind of these road traffic, drink driving related things, they will actually be allocated to the Magistrates Court because this is a summary offence. Any ideas what kind of offence we're talking about here then? So we've got the court as being the magistrates, and for some reason I can't see the chat anymore. I've been barred access.
I'll help you out with it. So have we already picked up on some of them already, maybe, Hannah, then? What you were talking about before around the drugs and the alcohol?
Mm-hmm. Absolutely. So the alcohol one is interesting. We need a bit more information though. So there is an offence which is called driving whilst exceeding the prescribed limit, and that is defined under Section 5 of the Road Traffic Act 1988. However, we need to know if he's over the limit, don't we? So we know that he's had a few glasses of wine, but people metabolise alcohol differently, don't we? So maybe we're going to need some further information. How would we get that information?
We've got some people also commenting on a slightly different note, but so somebody said medical report in terms of getting that information. Somebody's also raised a really interesting point. In addition to breathalyzer tests and blood tests, they've said, is the pub potentially partly responsible for allowing him to drive following drinking? I like where people are going with this stuff. And we also have a few people suggesting that maybe we've got grievous bodily harm going on here as well.
Okay, so we're specifying all of the different types of harm. I like the broad thinking, like can we connect the pub to serving him? So obviously under the law, the pubs aren't allowed to kind of carry on serving you if you are already intoxicated. And that's not just pubs, it's also shops cannot sell you alcohol if you appear intoxicated. And I've had the joy of refusing to serve people during my days in the co-op, and I'm sure a lot of you have had experiences of retail work in that vein. But we couldn't necessarily tie them directly into this. Like that would be a separate matter if we can prove that they were continuing to serve him while he was already drunk. The idea of the type of harm that has been sustained is interesting. So if we moved away from the idea of alcohol and maybe he was breathalyzed, but he was just under the limit so that we couldn't use that Section 5 of driving whilst exceeding the prescribed limit, we could maybe look at a few of the other offences, linking into some of your earlier observations. So a lot of you picked up on how he was distracted. And again, yeah, that may or may not have been influenced by the alcohol. But we have the idea in Section 3, we have careless driving. So we could have the idea that he was driving without due care and attention. And the standard we're looking at there is kind of the ordinary competent driver. And a competent driver would have looked left before turning left. So we could kind of look there saying that he satisfies the elements of that. Now, that's a pretty kind of common offence, and if no injury is caused by that offence, you get a fixed penalty notice, which some of you may have heard of, and that's basically 3 points on your licence and a £100 fine, so a slap on the wrist effectively. Here, serious injury has been caused, so he would be summoned to court for this, basically. He would be sent to the magistrates' courts, and he could be facing something quite serious, really, the idea of having 9 points on his licence, plus a fine up to the value of £5,000, and the magistrates could even disqualify him from driving. The fact that he's a new driver here actually counts against him, because if you kind of have, I think, again, I don't drive, but if you get more than 6 points within the first 2 years of driving your test, that's an automatic ban, and you have to retake your test. I may know someone that fell foul of that, but it was their own fault. But I won't go into that. But yeah, so we have the idea we could have ones that are offences tied into the alcohol, and then we could also take a look at more careless driving related offences. Grievous bodily harm is an interesting one, but we have something called like the mens rea, the intention. to perform the act, and that might be a bit difficult here. Like if he'd gone up to Priya with a hammer and kind of like smashed her head in, then yes, we can think about that, but with the car it could be a bit more difficult. So yeah, we've got the answer there. It will be the magistrates' courts.
Fantastic. Should we move on to the
Yeah,
second scenario?
Absolutely. So let's take a look at something that's a bit more contentious.
Perfect. Thank you, Hannah. The quick final one in the comments, I noticed that somebody said that surely the pub would be liable for so many crimes if they are responsible for anything a customer does whilst intoxicated. And I really love that somebody has picked up on that, because what you will notice as law students when your time comes is that we really do think in the law about the implications of the decisions too, right? And so you often will hear people thinking about policy decisions and that kind of thing, and that's where people are thinking, so if we allow this to happen in this scenario, what would the ramifications be? And if that is going to be super problematic, then that might be a consideration. And I think that that kind of ties into what we're going on to be thinking about, really. So we've been thinking so far in today's discussion about what the courts do and where we should go, which kind of courts we should go to in order to get our decisions made. We want to now, before we close, think about what should the courts do, and what is the remit of the court, and should that be the remit of the court. And in order to do that, we're going to give you the case of Charlie Gard as something to consider. So for those of us who are UK based, you might remember this case from a few years ago, back in 2016-17. It got a lot of international media coverage, so those of us outside of the UK might also have come across this one. But what I'm going to do is I'm going to very briefly talk you through some of the facts of this case, and then we're going to go on to have a bit of a discussion around where the court should be coming into effect here. So very quickly then, we have August 2016, Charlie Gard was born. In October of that year, unfortunately, he was diagnosed with mitochondrial DNA depletion syndrome, which is basically a genetic disorder causing progressive brain damage and muscle failure. A doctor in the United States was working on an experimental treatment, and arrangements were made for Charlie to be treated in the UK at Great Ormond Street Hospital, which is a famous children's hospital. It should be noted at that point that the doctor working on this experimental treatment, it was in a similar area to the kind of thing that Charlie had, but it wasn't exact. So this would very much be an experimental treatment that we're talking about. Unfortunately, by January 2017, even though steps had been made so that they could have this experimental treatment, Charlie had some seizures and they caused brain damage, and the doctors at Great Ormond Street believed that any further treatment would actually prolong his suffering and that Charlie should be moved to end-of-life care. Charlie's parents were understandably extremely upset by this situation, and they still wanted the experimental treatment to take place. So they sought to have him moved to the United States, and they'd actually raised the funds to do so themselves. Now, in February 2017, the doctors at Great Ormond Street applied to the High Court. So remember what Hannah said, the more complex cases can start in the High Court. So we've gone straight there for this one. They applied to the High Court to overrule Charlie's parents' decision in the belief that the experimental treatment would not be effective. So that's the scenario that we have. So in this situation, what we are basically dealing with is a consideration of whether or not the medical interventions in Charlie's life should continue. That is, what we're thinking about is what was in the best interests of the child, okay? So more specifically than that, we can then refine it further to if we've got a conflict between the parent's decision and the doctor's decision, then who gets to decide the best interests of the child in this scenario?
Okay, so I'll give you guys 10 seconds and then I'll click along to kind of get the results. Let's take a look at what we've been saying. Okay, so a lot of you have gone with the medical team there. Let's take a look at what's being said. Can I get the chat up? Only if I mute myself, so I will read and then mute myself.
I mean, in the chat we're seeing, we've actually seen in the chat, some people say here, doctors as the parents are too emotionally involved. Some people have said that there needs to be some kind of balance. And I think that that's a really interesting point, because you will find when you come to law school that we're constantly talking about this idea of balance. But what happens when there is such a conflict? We kind of need to break that balance, don't we? To some kind of, at the end of the day, a decision needs to be made, and either Charlie's going to proceed with the treatment or he's not. So it's difficult sometimes to get a balance between these kinds of things.
Okay, so I've unmuted. I just was able to take a quick look. So there's an interesting tension you guys are picking up on between the interests of the child and the interests of the parent. And someone has even suggested that the courts could actually revoke custody of the child in order to make sure that the child gets the treatment they need. Like, what do you think, Marie, about this tension between who should take priority, like the parents or the child? Like, what kind of approach do the courts take?
Do you know the brilliant thing about these kind of scenarios, when we're thinking about who ought to be making these decisions, is that there often is no right answer with these kind of things. So the tension that we're picking up on in the chat and in our comments of being so divided between the parents and the medical team is in reality the kind of tension that we encounter in the courts and in our approach to this kind of stuff, because there's no clear kind of way as to whether or not we think it should be in the remit of the parents or it should be in the medical team. And to be honest, one of those things that somebody picked up on about that balance is exactly what we strive for. So we will always try and get the parents and the medical teams to agree with these kind of things. Having said all of that, team, remember at the beginning we talked about human rights. Well, the case law here is very clear cut when it actually comes to thinking about the best interests of the child. And the reason why I say that is because what it will amount to is there is a long history of case law that will say it is the rights of the child that are going to take precedent in this situation. So that means that what we need to do in our court system, in our decision making, is we need to think, what is in the best interest of the child? So it's the rights of the child rather than the rights of the parents in this situation. So it doesn't necessarily help us decide who gets to say what the best interest is, but it does mean that we are placing emphasis on the rights of that child over the rights of the parent to decide.
I think those are some really interesting points, especially kind of like looking at that history of case law where you have those two tests. Is it about the parent's interest or the child's interest? Now, as you're alluding to, Marie, there's always going to be this tension between different parties. Now, very few of you kind of even gave the courts a look in on your responses to this question. You went straight to the medical team. So if there is going to be a conflict of views, should the courts intervene? So if we had the idea that the conflict between the parents and the child, should it be amicably kind of resolved between those two parties, or should the courts get involved? What do we think? So I'll give you 5 seconds for the purposes of time, and then I'll reveal the results. Okay, wow. Everyone has said yes. Why? Why do we have so much faith in our courts?
I really want to hear your views on this, guys. I knew that it was going to be more for the courts, but I didn't expect that it would be that high. Any kind of reasons for this?
We've got an interesting comment about the idea that maybe the parents have strict religious views, which could complicate the matter. So maybe we need this neutral arbiter. What do you think about that, Marie?
You know what, that's a really good point, and one of the things that sometimes we have to look at in this area of case law is, to what extent do religious views actually make a difference? Okay, so sometimes we could change this scenario, couldn't we? And would it have made a difference that the reason why Charlie's parents wanted him to survive, say, was because they had strong religious views? And in first year of the law degree, we do actually look into some cases like that, both with the withholding of medical treatment as well as the actual action of the medical treatment. What it comes down to is that point that I was saying about the rights. So because we are placing such emphasis on the rights of the child in our case law over the rights of the parents, in practice those kind of things don't make as much of a difference as we would probably, maybe some of us would think.
So those are really interesting points. We've had a few more comments just pop up that I can see whilst muted, but we have the idea like courts are unbiased. We have the idea that there may be some difficult conversations to be had in the process, the idea that funding may come into it, for example, and that the parents may not be open to discussing that as a relevant factor, and also the need for a quick resolution. So I think these are all really interesting points. But let's move on a little bit in this scenario to take a look at those opposing views.
Yeah, fantastic. So just as we kind of begin to draw our discussion to a close around this thing, one of the things that I was really mindful of, and you probably picked up on this in the way that I've discussed it, is that there really is often no clear view, which is why I was quite interested with so many of us saying, absolutely, this is for the courts. So I have just picked up on 4 different views here that I wanted to share with you, each from varying perspectives. So as I said, this case got a lot of media attention. So we have a statement from the Vatican, from the Pope, saying, for this he prays that their wish to accompany and treat their child until the end isn't neglected. We also have President Donald Trump here. So thinking about that political aspect, which unfortunately we've had no time to go into in today's discussion. If we can help little Charlie Gard, as per our friends in the UK and the Pope, we would be delighted to do so. A couple of the views that I'm more interested in are as follows. So this one from Jonathan Montgomery, who is a healthcare lawyer. He says, the external scrutiny of this tragic situation was often ill-informed. In law, medicine and ethics, this is a case about what was best for Charlie. The parents in the hospital always agreed on that. They interpreted his situation and the chances that the experimental treatment would help him differently. Quite properly, the issues were then put before the court for consideration. So you guys are all very much in line with what Montgomery is saying here. We want to have that kind of balance, and then if there is a conflict and we do need resolution, we definitely want to go before the courts. Notice too the external influence on that part there, because when we are looking at this stuff in law school, you will often find that the media influences do hold sway sometimes, and we need to kind of strip that out of our understanding of what's going on legally in scenarios, and you'll definitely pick that up in some of the public law cases we deal with. And then finally, Dominic Wilkinson, another professor who is a consultant neonatologist and a professor of medical ethics. Now, he says something really interesting, which some of us may or may not agree with, considering the conversations we've just had. He said that there are important lessons to learn from this case. Cases of deep disagreement between parents and doctors about treatment for a child are rare. Where they occur, it is often possible with time, patience, and support to find common ground. Where agreement cannot be reached, there is an important role for the courts in helping to reach a decision. However, court review of cases like this is not ideal. It is adversarial, costly, and lengthy. In this case, Charlie has received months of treatment that doctors and nurses caring for him felt was doing him more harm than good. So this picks up on some of the things that we've been discussing in the chat around this idea of time pressures and the courts getting involved in because of time pressures. But I wanted to just kind of emphasize this aspect of it, because as it turns out with these kind of things, very rarely do these kind of cases go to court. So as law students, we place great emphasis on the law, the law, the law, the courts, the hard cases, the difficult cases, going to the Supreme Court. A lot of the time, we want to avoid the courts at any cost. And so as law students, we are looking at a small proportion of what is actually taking place in and out of our legal system. So briefly then on the outcome of this case, the High Court actually supported the doctors in this decision. They said that it would be in the best interests of the child if Charlie were to be removed from life support and allowed to die with dignity. Charlie's parents then went on to appeal to the Court of Appeal, the Supreme Court, and, as we recall from the beginning of today's discussion, the European Court of Human Rights. Now, all three of those courts went on to uphold the High Court's decision that Charlie should be removed from life support. Now, the situation then did have further litigation before the end of the proceedings, but we're not going to go into that today. That was just to give us a little bit of a flavour of how complicated and difficult these decisions can be and what the role of the courts are. And more interestingly, for me at least, is what should the role of the courts be? And I hope that that's given you a bit of a flavour of that in our discussion. So with all of these scenarios, we want to try and give you, should we just do the wrap up, do you reckon, Hannah?
No, carry on.
Okay. I was going to move on to our three final points, but should we do another poll?
If a quick 5 seconds, I'm just it's my own personal curiosity.
Okay.
Have any of you changed your minds when it comes to who should make decisions in cases like this after listening to Marie's comments and the opinions of the experts? So I will click for the answers. We've got 5, and that's good enough for me, for my curiosity for now. Okay. So we've kind of shifted away from the medical professionals a little bit and gone to the courts. And
we've got more courts, so I've completely failed in saying, I wonder what the role of the court should be here. And I think that is a really interesting outcome. We've also got somebody in the chat saying the government, and unfortunately we haven't had time today to talk about the political influences of this. Now that is a shame, because as some of you may know, we are a critical law school in Kent Law School, and that means that we're really interested in the political influences and these kind of things. And you saw that I used Donald Trump's comment there because I was very interested around this case as to the political sway, the media sway, all of those different kind of things that were going on in the background of this decision that might have influenced not only the decisions of the parents and the medical team, but also potentially the influence on the court's decisions too. So in wrapping things up for everybody, we'd like to give you 3 quick things that we hope that you can have to take away from today's session and have a little bit more of a think about. So firstly, very straightforwardly, different types of courts deal with different types of cases. It's not just you go to court, there are different courts that we will be going to, and they will go to them for different reasons. Number 2, the courts, especially our more senior courts, deal with far fewer cases than we think. Remember that point that I was saying, these cases are minuscule in terms of the number of cases that would be around best interests of the child. In family law, in fact, we often want to avoid the courts at all costs and are required to avoid the courts at all costs before we instigate litigation. And finally, we spent a lot of time thinking about what the courts actually do. And I would urge us to not just have a good grasp about what the courts do, but to spend some time reflecting on what the courts ought to do and what ought their proper remit be.
And I completely agree with what Marie's just saying there. It's shifting the focus onto what courts ought to do. Now, I apologise for those of you that need to run. I abused my position as PowerPoint person to slow things down. But if you do want to be thinking about what courts ought to be doing, I've got a number of recommendations for you. So to start off with my English Legal Systems and Skills Convener hat on, the book that I would recommend if you want to find out more about how our legal system works and how our political structure influences the lawmaking processes and vice versa, I would take a look at Gary Slapper's How the Law Works. It's a book I recommend for both international students and home students that are a bit anxious about their grounding in law and politics. Maybe you haven't studied these topics before. Now, that's not fatal to doing a law degree by any imagination, but I understand it may leave some of you feeling a bit anxious about starting law school. So if you want to boost your knowledge, Slapper's a good place to start. If you want to kind of update yourself on the current challenges facing our legal system, there are a couple of things I would recommend. So the first one is Joshua Rosenberg's podcast, which is called Law in Action, and I've got the URL on the slide for you there. And I'd also recommend, like anything by The Secret Barrister, look at their book, follow them on Twitter, or go to Channel 4's YouTube website, page rather, and they've recently kind of published I think it's a 4 or 5 part series with The Secret Barrister, who hones in for 10 minutes at a time on key issues in our legal system, ranging from funding to the impact of COVID on justice. So that's for those of you that want to look at current debates. If those of you want to be looking at kind of, I suppose, the more political side we didn't get time for, like what should judges do? Like what are the boundaries when it comes to their role? I would recommend taking a look again, another piece by Joshua Rosenberg, his recent book entitled Enemies of the People, How Judges Shape Society. And I'd actually also recommend Lord Sumption's Reith lectures from 2019. Now, I will hold my hands up and I say Lord Sumption isn't entirely my cup of tea. So when you listen to him, you may not agree with some of the things he says, but he raises some really, really important questions that we can too easily overlook as law students obsessed with learning the law. So do give those 5 lectures a listen, bite your tongue when you disagree, and then try and think about why you disagree or why you agree with them. So yeah, that's my last little bit when it comes to recommendations. But I suppose the final thing is that both Maria and myself would really like to thank you for attending today's session.
And very, very quickly before we go, a final thing that was noticed in the chat is, what do you mean by ought to do? So I would just add that when I say ought to do, I mean what they should do. So should courts get involved in these things? And if they should, whose views maybe should be taking precedence? So is it the medical team? Is it the parents? So when we're talking around our oughts, we're also talking around our shoulds and whether or not that is the case. Thank you very much, everybody, for your wonderful engagement. It's been a pleasure to read all of your brilliant comments. I can see that some of you are going to make fantastic law students. And we really look forward to, and hopefully we'll see some of you in September.
Yeah, so take care and stay safe.
Thank you, everybody. Bye.